The APNU-AFC administration has now laid out its options moving forward regarding that successful opposition piloted no-confidence motion in the National Assembly on December 21. It is now the government's position that there was a miscalculation of the majority of all elected members as required under Article 1066 of the Constitution for the government to be defeated on a vote of no confidence. To this end, a legal memorandum was sent to Dr. Barton Scotland, the Speaker of the National Assembly, setting out the legal issues that the government wants him to consider.
As a citizen of both Ghana and Canada, Mr. Prasad is disqualified to be an elected member of the National Assembly, pursuant to Article 155(1) of the Constitution.
Attorney General and Minister of Legal Affairs Basil Williams. Though Prasad is now out, there might be other MPs in the National Assembly with dual citizenship, and how that will be looked at moving forward is another matter of interest. But already the dual citizenship of former government MP Charandas Prasad is being challenged. According to the Attorney General, the government's side has a very impressive legal lineup. Yet it took Attorney at Law Nigel Hughes to highlight an area of the Constitution that the government had overlooked. The government is also hoping that the Speaker will review his December 21 verdict after the verbal polling in the House.
Issue 4, the Speaker of the National Assembly is in duty bound to observe the Constitution as the supreme law of Ghana. Therefore, if there is a ruling of the Speaker which is unconstitutional, that error can be revisited and corrected by the Speaker. Issue 5, the Speaker can reconsider the resolution and reverse any decision he may have made and is not barred by the sub judice rule. This assertion is grounded in parliamentary practice and precedent.
If the Speaker finds the government's point of view untenable, then the government will approach the court in respect to the mathematical formula there. The Attorney General explained that the court is empowered to nullify the Speaker's decision. The Attorney General told a news conference on Monday that the government was not defeated by a majority as required under Article 1066 of the Constitution.
In order for the government to be defeated on a vote of confidence, 34 or more votes of all the elected members in favor of the motion were required instead of 33. This assertion is grounded in established parliamentary precedent and practice and case law in the Commonwealth. The ordinary and legal meaning of a majority is a number greater than half. According to Merriam-Webster Dictionary, 1828, majority rule is defined as, and I quote, a political principle providing that a majority usually constituted 50% plus one of an organized group will have the power to make decisions binding upon the whole, end of quote.
However, both the President and Prime Minister earlier accepted the results and consequences of the no-confidence motion.
The President wears many hats. One of them is the head of state. And he has a duty to ensure that the public peace is preserved. That matter could have gone anyhow, publicly, because, as I said, it was a betrayal. It was treacherous, and people suddenly dawned on them that another 23 years could be looming at them. You never know. So it behooved the President to ensure that he made a statement that would not inflame the issue and that people couldn't run on that basis and do mischief.
But going back to 2014, when the opposition at the time moved to file a no-confidence motion against the Donald Ramotar administration with only 33 members, is now being considered by the government as a scare tactic, since apparently they knew they needed more than 33 votes using the current formula.
Well, listen, that wasn't really something that we need to dwell on because the government never brought it up for a hearing as we've done. What they did was to prorogue the parliament and had one-man rule, our party rule for nearly half a year, three-quarters of a year.
So then the opposition knew that you needed 34 then.
The opposition knew that because they received an opinion from Mr. Stephen Fraser since 2014, which I have, telling them they need 34. So Mr. Nanalan, none of them knew that. What they didn't know is what I knew.
To now challenge the outcome of the motion, according to Minister Williams, is tactical. He said the government side had received information that a government MP or MPs may have sided with the opposition. Handel Duncan, HGP Nightly News.